Good morning. Welcome to the stream. Oh shit. Hold on. I need to turn this down a very significant amount. Sorry if that was really loud. I have a friend who I talk to on this thing. And this side. Yeah. This side of it has the gain. Hold on. I'm fucking it up. And I'm trying to get it so that way I don't have to keep going up and down on the gain volume. Or the gain. So that way I don't bust his eardrums whenever I have normal social chit chat off stream. Oh no, it's loose. I'll fix that later. So distance and gain helped. Hopefully that's not going to be a problem. Hello, my name is Jacob Davidson, and and this is Legal Layman, and I am from North Texas, where I try to learn. Should probably have figured out how to do my intro at this point. Jacob Davidson from North Texas. I'm Legal Layman, and I try to learn the law. Something like that. If you guys know any good, tax attorney, civil tax attorney, I would be happy to hear from them, because I need someone to help me go through that Fair Tax Act that I've been trying to go through, and it is rough. Where did I put the paper? $19. Magical Girl Venus. For where did I put that paper? Oh, right here. 5 minutes. Alright, gotta do it for 5 minutes. Alright, so my topics today will be the Trump indictment roundoff. I'll be doing the statement of facts. I saw an interesting article about the Texas Supreme Court giving the colleges and universities powers to revoke for academic misconduct that they found. Or revoke degrees for misconduct. And also Affroman. He apparently has responded to the cops, to the police lawsuit. And then I'll probably try to finish off that school voucher topic at the very end with the with the bill, Senate Bill 8 for the current session. Damn. Just gonna repost the link in the chat. pop out chat here. Alright. Hopefully that'll be everything I need for now. Trump indictment, statement of facts. There we are. Gonna move the code. The Senate Bill 8. That's on page 12. Okay. I didn't realize I picked the time where Friday Night Tights is on. So that sucks. Alright, see if I can't. I can't. Oh, that's gonna be a problem. Oh well. So, Trump statement of facts. Texas Supreme Court. I need to pull up that article real quick. I thought I connected it. Fuck. Here? Damn it. Oh well. There's a problem going on right now. There we go. And Affroman. Alright, I think I'm ready to get this show started in earnest. Got this right here. Let's go. I should just fix that real quick. Hold on. Oh shit. Hold on, I got something annoying. Alright, got that problem fixed. And let's do studio mode. What is my scene here? There we go. And here we are. Trump's statement of facts for his indictment. The people of the state of New York versus Donald J. Trump. Oh, and before that, this episode of the stream. Why do I? Yeah, there it is. This episode is. I've got for T from Dragon's Treasure, Magic Girl Venus. 5 minutes, and it is described as this orange flavored organic rooibos tea is a favorite of many due to its delicious combination of flavors, bringing together the bushy flavor of rooibos with orange peels and natural orange flavoring. This tea is generically named after a generic, non-identifiable magic girl who, like planets, and in no way infringes on any copyright. This magical girl may transform upon delivery. Awesome. Fantastic. I'll figure out how to say that later. Pretty good. So the introduction to the statement of facts. The defendant, Donald J. Trump, repeatedly and fraudulently falsified New York business records to conceal criminal conduct that hid damaging information from the voting public during the 2016 presidential election. To conceal criminal conduct that hid damaging information. So I should probably look into the falsify business records law. New York falsifying the specific account is for the specify count. It's for falsifying business records in the first degree. Under our law, a person is guilty of. I should figure out if this is the proper one. New York. New York State Senate. Hopefully this is the right place. Falsifying business records in the first degree. Falsifying business records in the first degree. A person is guilty of that offense when he commits the crime. Falsifying business records in the second degree. Wait, what? A person is guilty of falsifying business records in the first degree when he commits the crime of falsifying business records in the second degree, and when his intent to defraud includes an intent to commit another crime or to aid or conceal the commission thereof. I guess the question now is, what does it look like in the second degree? A person is guilty of falsifying business records in the second degree when with the intent to defraud he makes or causes a false entry in business records of an enterprise, alters, erases, obliterates, deletes, removes, or destroys a true entry in the business records of an enterprise, or omits to make true entry in the business records of an enterprise in violation of a duty to do so which he knows to be imposed upon him by law or by the nature of his position, or prevents the making of a true entry or causes the omission thereof in the business records of an enterprise. Falsifying business records in the second degree is a Class A misdemeanor. Alright, going back to this. Doing it in the first degree is a Class E felony. And this upgrades it to a first degree if the fraud includes an intent to commit another crime or to aid or conceal commission thereof. So he has to have done the falsification of the business records with the intent to hide another crime. No, wait. To hide the crime or with the intent to commit another crime. But that assumes that what he did was criminal to begin with. I guess these could stack. So, like, the first misdemeanor could be... Is that their idea? That the misdemeanor could... Hiding misdemeanor 1 with misdemeanor 2. Misdemeanor 2 could... hides misdemeanor... Or misdemeanor 3 hides 2. 4 hides 3. Something like that. Which would make it this. Is that what they're thinking? But what are the statutes of limitations? Statute of limitations. New York. Falsifying. Most felonies in New York is 5 years, including charges of falsifying business records that Trump is facing. There are exceptions to this limit for certain crimes such as first-degree murder, which do not have statutes in the state. Well, I guess I know what the question's for. Statute of limitation extension, New York. Signed on September 4th, 2020. Further, any specific time limited for the commencement, filing, or legal services. Out of state. There's a way it extended, I believe. Libel slander, 1 year from the act. Petty offenses. Business. Nope. Class A felony. Do they have any of the Class E felonies? No statutes, no time limits, depending on facts. Other felonies are 5 years. Misdemeanor 2 years. There was something that extended. Oh well. So he apparently did conceal criminal conduct that hid damaging information from the voting public. From August 2015 to December 2017, defendant orchestrated a scheme with others to influence the 2016 presidential election by identifying and purchasing negative information about him to suppress its publication and benefit the defendant's electoral prospects. In order to execute the unlawful scheme, the participants violated election laws and caused false entries in the business records of various entities in New York. The participants also took steps that mischaracterized for tax purposes the true nature of the payments made in furtherance of the scheme. One component of the scheme was that, at the defendant's request, a lawyer who then worked for the Trump Organization as a special counsel to defendant Lawyer A covertly paid $130,000 to an adult film actress shortly before the election to prevent her from publicizing a sexual encounter with the defendant. Lawyer A made the payment, or made the $130,000 payment through a shell corporation he set up and funded at a bank in Manhattan. This payment was illegal, and lawyer A has since pleaded guilty to making an illegal campaign contribution and served time in prison. Further, false entries were made in New York business records to effectuate this payment, separate and apart from the New York business records used to conceal the payment. After the election, the defendant reimbursed lawyer A for the illegal payments through a series of monthly checks, first through Donald J. Trump Revocable Trust, the defendant's trust, a trust created under the laws of New York which held the Trump Organization entity assets after the defendant was elected president. Trusts in New York. Let's see. Trusts in New York State. Under New York laws, a lifetime trust is created by a person who is still alive rather than upon a person's death through a will. Any person 18 or older may dispose of property through a lifetime trust. Every estate held in property may be disposed by lifetime trust. Revocable trusts? Revocable trusts, or revocable living trust, sometimes known as inter vivos trusts, provides many advantages that may make it desirable part of your estate planning process. I don't want the Bar Association. This might be a little too above my head on this one. After the election, revocable trust, a trust created under New York laws, which held Trump Organization entity assets when he was elected president. And then from the defendant's bank account, each check was processed by the Trump Organization, and each check was disguised as payment for legal services rendered in a given month of 2017 pursuant to a retainer agreement. The payment records kept and maintained by the Trump Organization were false New York business records. In truth, there was no retainer agreement. Lawyer A was not being paid for legal services rendered in 2017. The defendant caused his entity's business records to be falsified to disguise his and others' criminal conduct. From what I've been understanding, oh, hey there, hope you're having a better week listening as I've been having a better listening as I work. Hey Danielle, my week is about to start. I'm about to go to work in about 3 hours. Well, 2 hours. Well, 3 hours is 6:45. Then I go to work at 7:37. About 3 to 4 hours. Just, some early streaming time to kill the time. Hopefully you'll have a good day at work. Thank you for listening. But yes, from what I've been hearing, buying someone's negative story and not having them say it is not illegal. There's a lot that this case has to prove, apparently. Background. The defendant is the beneficial owner of a collection of business entities known by the trade named the Trump Organization. The Trump Organization comprises approximately 500 separate entities that, among other business activities, own and manage hotels, golf courses, commercial real estate, condominium development, and other properties. The Trump Organization is headquartered at 725 Fifth Avenue in New York County. From approximately June 2015 to November 2016, the defendant was a candidate for the office of the President of the United States. On January 20, 2017, he became President of the United States. The scheme. The catch and kill scheme to suppress negative information. During and furtherance of his candidacy for president, the defendant and others agreed to identify and suppress negative stories about him. Two parties to this agreement have admitted to committing illegal conduct in connection with the scheme. In August 2018, Lawyer A pleaded guilty to 2 federal crimes involving illegal campaign contributions and subsequently served time in prison. In addition, in August 2018, America Media Incorporation, or AMI, a media company that owned and published magazines and supermarket tabloids, including the National Enquirer, admitted in a non-prosecution agreement that it made a payment to a source of a story to ensure the source did not publicize damaging allegations about the defendant before 2016 presidential elections and thereby influence the election. You know, they talk about influencing elections, but it seems to happen regularly without punishment every other time. You have some guy who texted out or made a meme or posted a meme about texting to Hillary to vote, and that wasn't seen as evil, or that was seen as evil and bad, and got a guy convicted for First Amendment. And now this seems to be about influencing an election unduly, when it's just he didn't want a bad story coming out. It's a little hypocritical. Hold on. Orangey, yes. The 2015 Trump Tower meeting. In June 2015, the defendant announced his candidacy for President of the United States. Soon after, in August 2015, the defendant met with Lawyer A and AMI's chairman and chief executive officer, the AMI CEO, at Trump Tower in New York City, or New York County. At the meeting, AMI CEO agreed to help with the defendant's campaign, saying that he would act as the eyes and ears for the campaign by looking out for negative stories about the defendant and alerting Lawyer A before the stories were published. AMI CEO also agreed to publish negative stories about the defendant's competitors for the election. Nothing wrong with that. Simple campaign contributions. Suppressing the doorman story. A few months later, in or about October or November of 2015, the AMI CEO learned that the former Trump Tower doorman, or the doorman, was trying to sell information regarding a child that the defendant had allegedly fathered out of wedlock. At the AMI CEO's direction, AMI negotiated and signed an agreement to pay the doorman $30,000 to acquire exclusive rights to the story. AMI falsely characterized the payment in AMI's books and records, including in its general ledger. AMI purchased the information from the doorman without fully investigating his claims, but the AMI CEO directed that the deal take place because of his agreement with the defendant and Lawyer A. So their crime was apparently buying up a story and falsifying the payment. Falsely characterizes payment. When AMI later concluded that the story was not true, the AMI CEO wanted to release the doorman from the agreement. However, lawyer A instructed the AMI CEO not to release the doorman until after the presidential election, and the AMI CEO complied with that instruction because of his agreement with defendant and lawyer A. Suppressing Woman 1's account. About 5 months before the presidential election, in or about June 16th, the editor-in-chief of the National Enquirer and AMI's chief content officer, or AMI editor-in-chief, contacted lawyer A about a woman 1, who allegedly had sexual relationship with the defendant while he was married. The AMI editor-in-chief updated lawyer A regularly about the matter over text message and by phone. The defendant did not want this information to become public because he was concerned about the effect it could have on his candidacy. Thereafter, the defendant, the AMI CEO, and lawyer A had a series of discussions about who should pay off Woman 1 to secure her silence. The AMI ultimately paid $150,000 to Woman 1 in exchange for her agreement to not speak out about the alleged sexual relationship, as well as for 2 magazine cover features of Woman 1 and a series of articles that would be published under her byline. AMI falsely characterized the payments in the business records, including in its general ledger. But how did they do that? I want to know how they falsified these, or falsely characterized these payments. What should the proper payment characterization be, and what is the false one? The AMI CEO agreed to the deal after discussing it with both the defendant and lawyer A, and on the understanding from lawyer A that the defendant or the Trump organization would reimburse AMI. The conversation captured in an audio recording in approximately September 2016 concerning Woman 1's account. The defendant and lawyer discussed how to obtain the rights to Woman 1's account from AMI and how to reimburse AMI for its payment. Lawyer A told the defendant he would open up a company for the transfer of Woman 1's account and other information, and stated that he had spoken to the chief financial officer of the Trump organization, CFO, about how to set the whole thing up. The defendant asked, "So what do we got to pay for this? $150?" and suggested paying by cash. When lawyer A disagreed, the defendant then mentioned payment by check. After the conversation, lawyer A created a shell company called Resolution Consultants, LLC, on or about September 30th, 2016, less than 2 months before the election, on or about September 30th. The AMI CEO signed an agreement in which AMI agreed to transfer its rights to Woman 1's account to lawyer A's shell company for $1,250 or $125,000. I spoke a whole set of wrong numbers. Transfer to lawyer A's shell company for $125,000. However, the assignment agreement was signed, but before the reimbursement took place, the AMI CEO consulted with AMI's general counsel and then told lawyer A that the deal to transfer the rights to lawyer A's shell company was off. Because the shell company looks suspicious as fuck. That Magical Girl Venus tea is really good. Like, really, really good. How many times can I rebrew it? 1 to 2 times. It's probably going to get really loud in just a moment. Suppressing Woman 2's account about 1 month before the election, on or about About 1 month before the election, on or about October 7th, 2016, news broke that the defendant had been caught on tape saying to the host of Access Hollywood, "I just start kissing them, women. It's like a magnet. Just kiss. I don't even wait. And when you're a star, they let you do it. You can do anything. Grab them by the genitals or grab them by the pussy. You can do anything, or you can do anything." The evidence shows that both the defendant and his campaign staff were concerned that the tape would harm his viability as a candidate and reduce his standing with female voters in particular. Turned out it became a legendary tape. Shortly after the Access Hollywood tapes became public, the AMI editor-in-chief contacted the AMI CEO about another woman too, who allegedly had sexual encounter with the defendant while he was married. The AMI CEO told the AMI editor-in-chief not to notify Lawyer A. On or about October 10, 2016, the AMI editor-in-chief connected with Lawyer A with Woman 2's lawyer, Lawyer B. Okay. My kettle's vibrating violently. So in 5 minutes, that'd be 4:03. Cool. I need to start losing weight. This is unacceptable. I'm looking at myself and it's like, God damn, you fat fuck. Shortly after Access Hollywood tape became public, the AMI editor-in-chief, Woman 1... Okay, Lawyer B. Lawyer A then negotiated to deal with Lawyer B to secure Woman 2's silence and prevent disclosure of the damaging information in the final weeks before the presidential election. Under the deal that Lawyer B negotiated, Woman A would be paid $130,000 for the rights to her account. This would probably be Stormy Daniels because this is the number. The defendant directed Lawyer A to delay making the payment to Woman 2 as long as possible. He instructed Lawyer A that if they could delay the payment until after the election, they could avoid paying altogether, because at that point it would not matter if the story became public. As reflected in emails and text messages between Lawyer A, Lawyer B, the AMI editor-in-chief, Lawyer A attempted to delay making payments as long as possible. Ultimately, with pressure mounting and the election approaching, the defendant agreed to pay off and direct Lawyer A to proceed. Lawyer A discussed the deal with the defendant and the Trump Organization CFO. The defendant did not want to make the $130,000 payment himself, and asked Lawyer A and the Trump Organization CFO to find a way to make the payment. After discussing various payment options with the Trump Organization CFO, Lawyer A agreed he would make the payment. Before making the payment, Lawyer A confirmed with the defendant that defendant would pay him back. On or about October 26, shortly after speaking with the defendant on the phone, Lawyer A opened a bank account in Manhattan in the name of Essential Consultants LLC, a new shell company he had created. A new shell account he had created to effectuate the payment. He then transferred $131,000 from his personal home equity line of credit, HLOC, HELOC. I'll just call it the home equity line. Into the account on or about October 27th. Lawyer A wired $130,000 from his Essential Consultants account in New York to Lawyer B to suppress Woman's 2 account. Post-election communications with AMI CEO. On November 8, 2016, the defendant won the presidential election and became the president-elect. Thereafter, AMI released both the doorman and woman 1 from their non-disclosure agreements. The defendant was inaugurated as president on January 2017 between Election Day and Inauguration Day. During the period of the defendant's transition to his role as president, the defendant met with AMI CEO privately in Trump Tower in Manhattan. The defendant thanked the AMI CEO for handling the stories of the doorman and woman 1, and invited the AMI CEO to the inauguration in the summer of 2017. The defendant invited the AMI CEO to the White House for dinner to thank him for his help during the campaign. Man, I would want to eat dinner with this guy. He sounds like a great guy. There's my tea. It's great because the tea even looks orange. Before it's all drained out. See how orange it is? Dragon's Treasure, everybody. I'm probably going to invest. Might get about 1,000 views or 1,000 subscriptions. Gosney! Hey, man! How you doing? Oh, Gosney, Danielle is listening while she works. If she didn't hear my my exclamation, she probably doesn't know that you're here. Everybody just stopping by to like and say hello. Happy to see you, man. I read through the first chapter of your book, or the first main topic. I didn't think the chapter had anything to do with the topic, and it's great. She's my mentoree. Oh. Man, I will be watching the Vices stream tonight then. Hopefully I'll be able to enjoy something while I work. Gosney, do you know any civil tax lawyers I can get in contact with? I need some help with one of my longer term topics. I don't need a tax attorney for personal tax reasons, but I've been covering something called the Fair Tax Act. Damn it. Not really, sorry. Well, that's fine. Thank you for stopping by. I very much appreciate it. If Danielle doesn't know that you stopped by when you leave, she'll probably see you and I'll probably tell her that you said hi. Alright, the defendant was inaugurated. Where did I lost my place. I'd like to log on to folks to get their watch hours up, so I leave this in the background. Sweet. You probably already heard this statement of facts about a dozen times from different Law 2 people, so I would understand if it probably ended up on a mute. I have lost my place. Oh no, wait, I found my place. I just finished talking about the dinner. The defendant falsified business records. Shortly after being elected president, the defendant arranged to reimburse lawyer A for the payoff he made on the defendant's behalf. In or about January 2017, the Trump Organization CFO and lawyer A met to discuss how lawyer A would reimburse for the money he paid to ensure woman 2's silence. The Trump Organization CFO asked lawyer A to bring a copy of the bank statement for the central consultant account showing the $130,000 payment. The Trump Organization CFO and lawyer A agreed to the total repayment amount of $420,000. They reached that total figure by adding $130,000 payment to a $50,000 payment for another expense for which lawyer A also claimed reimbursement. For a total of $180,000, the Trump Organization CFO then doubled that amount to $360,000 so that lawyer A could characterize the payment as income on his tax return instead of a reimbursement. Lawyer A would be left with $180,000 after paying approximately 50% in income taxes. Finally, the Trump Organization CFO added an additional $60,000 as supplemental year-end bonus. Together, this amount totaled $420,000. So he paid 50% of what he would have been paid in income taxes, and then got $60,000 later, being paid more than he'd spent in total. The Trump Organization CFO memorialized these calculations in a handwritten note on the copy of the bank statement that lawyer A had provided. The defendant, the Trump Organization CFO, and lawyer A then agreed that lawyer A would be paid $420,000 through 12 monthly payments of $35,000. Man, $35,000 a month. I would be a happy person. Over the course of 2017, each month lawyer A was to send an invoice to the defendant through Trump Organization employees, falsely requesting payment of $35,000 for legal services rendered in a given month of 2017 pursuant to a retainer agreement. At no point did lawyer A have a retainer agreement with defendant or the Trump Organization. Oh no. Oh no. See goody, no. Hold on. Just gonna reply to this. Oh, real quick side tangent. Steve, you're still there. You remember how on the Murdaugh trial, one of the facts stated somewhere about the story that Alex Murdaugh said was not accurate or consistent was like he lost some item in between the console and seat of his car? I had lost a phone ages ago, like last year ago. And I ended up finding my lost phone between the console and the seat of my car while cleaning it out for a wedding. I was flabbergasted. Still warm. Or hot, rather. Let's see here. At no point did lawyer A have a retainer agreement. Cool. In early February 2017, the defendant and lawyer A met in the Oval Office at the White House to confirm this payment confirm this repayment arrangement, rather. On or about February 14th, 2017, lawyer A emailed the controller of the Trump Tower Organization, or Trump Organization Controller, the first monthly invoice, which stated, pursuant to the retainer agreement, kindly remit payment for services rendered for the months of January and February 2017. The invoice requested payment in the amount of $35,000 for each of those 2 months. The Trump Organization CFO approved the payment, and in return, the Trump Organization controller sent the invoice to the Trump Organization accounts payable supervisor, or the TO accounts payable supervisor, which is basically the same thing, with the following instructions: post to legal expenses, put retainer for the months of January and February in 2017 in the description. Lawyer A submitted 10 similar monthly invoices by email to the Trump Organization for the remaining months in 2017. Each invoice falsely stated that it was being submitted pursuant to the retainer agreement. Just making sure that my voice is being registered. I forget to check my voice levels on this thing. I'll need to retighten my microphone. And falsely requested. Each invoice falsely stated that it was being submitted pursuant to the retainer agreement and falsely requested payment for services rendered for a month of 2017. If I remember right, these things are true. These things are like, it's not a false record, it's a genuine record. In fact, there was no such retainer agreement, and Lawyer A was not being paid for services rendered in any month of 2017. The Trump Organization controller forwarded each invoice to the Trump Organization accounts payable supervisor, consistent with the Trump Organization's controller's initial instructions. The Trump Organization accounts payable supervisor printed out each invoice and marked it with an accounts payable stamp and the General Ledger Code 51505 for legal expenses. The Trump Organization maintained the invoices as records of expenses paid. As instructed, the Trump Organization accounts payable supervisor recorded each payment in the Trump Organization's electronic accounting system, falsely describing it as a legal expense. Pursuant to a retainer agreement for a month of 2017, the Trump Organization maintained a digital entry for each expense called a voucher. These vouchers, like vouchers for other expenses, became part of Trump's Organization general ledgers. The Trump Organization accounts payable supervisor then prepared checks with attached check stubs for approval and signature. The first check was paid from the defendant's trust and signed by the Trump Organization CFO and the defendant's son as trustee. The check stub falsely recorded the payment as retainer for 1/1 through January 1st to January 31st, 2017, and retainer for February 1st to February 28th, 2017. The second check for March 2017 was also paid from the trust and signed by 2 trustees. The check stub falsely recorded the payment as retainer for March 31st through March 1st to March 31st, 17. The remaining 9 checks corresponded to the months of April through December of 2017 were paid by the defendant personally. Each of the checks was cut from the defendant's bank account and sent along with the corresponding invoices from Lawyer A. From the Trump Organization in New York County, the defendant in Washington, D.C., the checks and stubs bearing the false statements were stapled to the invoices also bearing false statements. The defendant signed each of the checks personally and had them sent back to the Trump Organization in New York County. The checks, the stubs, and the invoices were scanned and maintained by the Trump Organization's data systems before the checks themselves were detached and emailed to Lawyer A for payment. The $35,000 payment stopped after the December 27th payment. Investigation. Hold on. Sorry about that. The investigation into Lawyer A and the defendant's pressure campaign. On or about April 9th, 2018, the FBI executed a search warrant on Lawyer A's residence and office. In the months that followed, the defendant so it was only 2 years into his presidency, and they executed a search warrant. The defendant and others engaged in a public and private pressure campaign to ensure that Lawyer A did not cooperate with law enforcement in the federal investigation. Which is proper. Do not talk to the feds. If you talk to a fed, you're a snitch, and snitches get stitches. On the day of FBI searches, Lawyer A called to speak with the defendant to let him know that what had occurred. In return call, the defendant told Lawyer A to stay strong. On or about April 21st, 2018, the defendant publicly commented on Twitter encouraging Lawyer A to not flip, stating, "Most people flip if the government lets them out of trouble, even if it means lying or making up stories. Sorry, I don't see Lawyer A doing that." And there's nothing wrong with this statement. It's actually true. I have been disillusioned by the state well enough to know that the government will just harass you and keep you there and try to drain you of all your resources to get something out of you if they can get something to attack their opponent. This much is very, very true. In mid-April 2018, Lawyer A was also approached by an attorney, Lawyer C, who offered to represent him in the interest of maintaining a back channel of communication to the defendant. On or about April 22nd, 2018, Lawyer C emailed Lawyer A highlighting that he had a close relationship with the defendant's personal attorney, Lawyer D, ACDC. And stating this could not be a better situation for the president or you. Later that day, Lawyer C emailed Lawyer A again, writing, "I spoke with Lawyer D, very, very positive. You're loved." Lawyer D said, "This communication channel must be maintained. Sleep well tonight. You have friends in high places." On or about June 14th, 2018, Lawyer C emailed Lawyer A as news clips discussing the possibility of Lawyer A cooperating, and continued to urge him not to cooperate with law enforcement, writing, "The whole objective of this exercise by the federal prosecutors is to drain you emotionally and financially until you reach a point where that you see them as your only means to salvation." In the same email, Lawyer C wrote, "You're making a very big mistake if you believe the stories these journalists are writing about you. They want you to cave, they want you to fail, and they don't want you to persevere and succeed." On August 21st, 2018, Lawyer A pleaded guilty in the federal investigation. The next day, on or about August 22nd, 2018, the defendant commented on Twitter, If anyone is looking for a good lawyer, I would strongly recommend that you don't retain the services of Lawyer A." Michael Cohen is not liked anymore. Later that day, the defendant posted to Twitter again, stating, "I feel very badly for one of his former campaign managers who had been criminally charged," saying, "Unlike Lawyer A, he refused to make up stories in order to get a deal. Lawyer A and AMI admit guilt in connection with payoffs of Woman 1 and Woman 2. Ultimately, other participants in the scheme admitted that payoffs were unlawful. Just because they admit it doesn't mean it's so. Saying something doesn't make it so. In or about September 28th, AMI entered in a non-prosecution agreement with the United States Attorney Office for the Southern District of New York in connection with AMI's payoff of Woman 1, admitting that at no time during the negotiation or acquisition of Woman 1's story did AMI intend to publish the story or disseminate information about it publicly. Rather, AMI admitted that made the payment to ensure that Woman 1 did not publicize damaging allegations about the defendant before 2016 elections and thereby influence that election. In August 21st, 2018, Lawyer A pleaded guilty to a felony in connections with his role in AMI payoff to Woman 1, admitting his guilty plea that he had done so at the defendant's direction. On or about the summer of 2016, in coordination with and at the direction of a candidate for federal office, I and the CEO of a media company, at the request of the candidate, worked together to keep an individual with information that would be harmful to the candidate and to the company in the campaign from publicly disclosing this information. After a number of discussions, we eventually accomplished the goal by the media company entering into a contract with the individual under which she received compensation of $150,000. There we go. I participated in this conduct, which on my part took place in Manhattan for the principal purpose of influencing the election. Emphasis added. Lawyer A also pleaded guilty to a felony connection with the payoffs of Woman 2 to secure her silence against the defendants. Again, at the defendant's direction. Lawyer A admitted as a part of his guilty plea. I hate guilty pleas at this point, even if they are proper. On or about October 2016, in cooperation or coordination with and at the direction of the same candidate, I arranged to make a payment to a second individual with information that would be harmful to the candidate and the campaign to keep the individual from disclosing the information. To accomplish this, I used a company that was under my control to make a payment in the sum of $130,000. $130,000. The monies I advanced through my company were later repaid to me by the candidate. I participated in this conduct, which on my part took place in Manhattan for the principal purpose of influencing the election. Well, the statement of facts contains certain of the information that is relevant to the events disclosed hereby does not contain all facts relevant to the charged conduct. And I've made it through my first whole document of the streams ever. Dated New York, April 4th, 2023. Alvin Bragg Jr., District Attorney of New York County. So basically they want to use a guy who's convicted to sell a conviction for Trump. Oh, what fun it is to ride the political arrest system. Damn it. And that concludes the Trump topic. I have nothing else to really say about it outside of, from my understanding of the First Amendment, you have more protections to keep things quiet than to say things. The quieter things are, the more it's protected. With that, I would like to go to my second topic. The Supreme Court, or Texas Supreme Court and colleges. The Texas Supreme Court rules that universities can revoke degrees for academic misconduct. I found this pretty interesting. I saw this one night when the power turned off for like 30 minutes and I had to deal with it. Oh, fuck. I did not like what I just saw. Oh no. Oh no. House voted 130 to 10 to pass its proposal for how to spend more than. Just try it out, Texas. Fuck's sake. It's a failing system. Try something new. I'll look at this at the very end. The Supreme Court has ruled that universities in the state can revoke a former student's degree for academic misconduct, reversing previous ruling from the lower courts. In a separate but consolidated case, the University of Texas and Texas State University argued for the right to revoke awarded doctorate degrees from students who engaged in academic misconduct in part, to protect their reputations and the value of degrees conferred upon their students. Attorneys for the students argued that the state law did not give universities the authority to revoke students' degrees, but the court, in a divided decision Friday, disagreed. The court found that universities can revoke degrees as long as the university provides due process to the students, and if the conduct justifying the revocation of the degree occurred while the student was enrolled, even if they have already graduated. Which at this point would make sense, because if you could not revoke someone's degree for the misconduct of their education process after they've graduated, you would not be able to if they had already graduated, because you can't really punish that if you caught it too late. Though I guess the problem is they don't exactly have to abide by due process in a lot of situations, or if they do, a lot of mistakes can be made in the due process aspect. And if they deem conduct justifying the revocation of the degree, they could start making policies that bad think or wrong think is the justification, or the conduct justification. The case each involves separate students accused of academic misconduct who sued to prevent the universities from revoking their degrees. At Texas State University, a former graduate student known as K.E. sued the school for attempting to revoke her doctoral degree in biology after an investigation found that she had falsified and fabricated
data in her dissertation in 2011. In a similar case, Suvi, or a UT student, sued the school after it began the process to revoke her doctoral degree in chemistry from 2018 after allegations of academic misconduct surfaced 4 years later. A university committee ultimately found that she had engaged in scientific misconduct or claimed she made a mistake and misread data. Oh. The court's ruling reversed the decision the trial court and third district court of appeals, both of which ruled against the two universities. The appeals courts found the state law grants universities the authority to award degrees but doesn't explicitly say that schools can revoke them. Under the Texas Education Code, the Texas State University system is responsible for the general control and management of the universities in the system, and it may determine the conditions for the award or of certifications diplomas. The code also provides the UT system the authority to govern and maintain all of the institutions and award degrees. Should be strictly within the law. If the law doesn't say that it has the right, it doesn't have the right. But also, I think that the due process portion would cover this. Because if they just ask her to amend the data in her dissertation, if she misread it, then that would be a way to fix it. That she claimed, or claimed she made a mistake and misread data. Professor critical. In the Friday ruling, Justice Deborah Learman wrote, "The universities have the authority to revoke degrees under state law." She said the statute governing the UT and Texas State boards of regents give them the authority to enact disciplinary rules and policies regarding academic misconduct, as well as expel current students who engage in misconduct. I need to find this law. Laws. Texas University laws. Texas Education Coordinating Board. Back to dark mode. That goes. Texas Higher Education Coordinating Board, State Coordinating Higher Education, General Provisions. She found disciplinary actions. Disciplinary. With an emphasis that the rules relate to disciplinary. Okay. Determination of discipline of internal auditor. Authority. New contract and repair and rehabilitation. Appropriations. Coordinating institutions. The board represents the highest authority of the state in the matter of public higher education and is charged with the duty under rule describes the board may revoke or place conditions on an institution or person's exemption status. Revocation of certificate of authority. The board may revoke a certificate of authority to grant degrees at any time it finds the institution has failed to maintain the faculty, facilities, equipment, programs to study. Degree. Issuance of certificate of authority to grant a degree or degrees is valid for 2 years from the date of issuance. The board may not issue a certificate of authority for a private post-secondary education institution. College and university degrees. Is a policy purpose of the state of Texas to prevent deception and public results from conferring the use of fraudulent and substandard colleges and university degrees. Is also the purpose of the subchapter. Degree means any designation, mark, abbreviation, appellation, or series of letters or words, including associate, bachelor's, master's, doctors, and their equivalents, which signifies purports to or is generally taken to signify satisfactory completion of the requirements of all the parts of a program of study leading to an associate, bachelor's, master's, or doctor's degree or its equivalent. Mathematics, science. Study on religious studies programs at a university. Where's the law even found at? Friday ruling, Justice Deborah wrote that universities have the authority to revoke degrees under state law. She said that statutes governing the UT and Texas State Boards of Regents gives them the authority to enact disciplinary rules and policies regarding academic misconduct. I should go back and look up academic misconduct. Punishment, punish. Is this for public education? Oh no. I'll have to find this later. I cannot. The only difference between expelling a current student for academic misconduct and revoking a student degree for the exact same academic misconduct is one of timing, Lehrman wrote. Lehrman wrote that while there was no precedent on the issue in Texas and little elsewhere, other courts have uniformly determined that public universities have degree revocation power, including Ohio, Virginia, North Dakota, and New Mexico, under similarly worded grants of authority. Justice Jimmy Blacklock wrote in his dissent that universities have the power to manage their internal affairs, but not the affairs of graduates, including by revoking their degrees after they have been awarded. He wrote that the power to decide whether a degree should be revoked rests with the courts, not universities. A degree belongs to me, not to universities. Like other valuable assets in my possessions, it cannot unilaterally be taken from me by those who later decide I never should have had it, Blacklock wrote. Our Constitution establishes courts, not universities, to adjudicate disputes about ownership and possession of property. Oh, I like this argument. Texas Supreme... Wait, that's not the one I should use. Texas Supreme Court, Blacklock. I like his argument. And Lehrman. Attorney Justice drops. Justice Lehrman. And Friday ruling. 31 pages. I'll read this later in private and then go over it. All right. So that concludes the Supreme Court argument, or the Supreme Court, or Texas Supreme Court statements on this matter. It is very interesting, actually. I did not think too much about this until it popped up. And now that I have it, interesting. So Lehrman delivered the opinion of the court, which Justice Hecht... So Hecht, Busby, Bland, and Huddle and Young joined in. Okay, so... Oh, wait. So 1, 2, 3, 4, 5, 6. 6 of them. Agreed. 1 concurred. And 2 disagreed. Blaylock and Devin. These 2 disagree. This one concurred. Everyone else was in it. Busby and Bland. How unfortunate to have a name Bland. A degree belongs to me, not to universities. I like that opinion. Alright, that wraps up the Supreme Court and Texas Supreme Court versus the college thing, or college degrees. Affroman. If you don't know him, he is a guy who got his house raided by the police, had security footage of that raid, and then made a song about getting raided by the police. Fun time for everyone all around. Affroman fires back at Adams County deputies who are suing him. Hopefully he fires back more. I was gonna clean my room, and then I got high. I can make one more brew with this. I'm gonna take a mild soft moment. Just gonna rebrew the water. It's gonna get pretty loud in a moment, so hopefully this will resolve that significantly. I would swing it around to show it, but you would see a lot more of the room. It shouldn't take as much because it's less water. Just gonna... Sweet. The kettle is relaxing. Adams County, Ohio. I think this is the news. WXIX. I don't know what that means. Rapper Affroman says he will not stop using videos of Adams County deputies raiding his home to... $56, let's go. Yes, he will not stop using videos of Adams County deputies raiding his home to promote both his music and his merchandise. After those deputies sued him, saying Affroman is causing harm not only to their lives but to their families as well. You know, I made jokes out of what they did, and they're suing me for humiliation. You know. That's what I feel every day, and that's what I felt when they kicked down my door and went to, and then want to offer to help me out. Want to offer to help me out. Once they didn't find drugs being trafficked, once they didn't get that from victims, Affroman said. That's what I feel every day, and that's what I felt when they kicked down my door and then want to offer to help me out. In August 2022, the Adams County Sheriff's Office used a signed affidavit claiming probable cause of human trafficking and drug activity to raid the rapper's property. After many months and a long investigation, deputies said nothing was found and no charges ever materialized. Affroman is now putting images that were captured from the surveillance cameras of the raid on the merchandise and in the music video. He says profits from sales are helping him rebuild his life and repair his property. Once they didn't find drugs being trafficked, once they didn't find kidnapping victims, they didn't apologize to me as an American citizen, Affroman said. He says the pictures and videos of the deputies were taken on its own surveillance systems, which under the law makes them his property. They are public figures. If they are really concerned about their privacy, they wouldn't be putting their names on a public lawsuit. They obviously don't care about their privacy, he said. The deputies' lawsuit claims the Afroman has caused them to suffer irreparable injury to their reputation and mental health. My understanding is that threats were not even coming from Adams County, but from the West Coast, from states far away. Attorney for the deputies, Robert Klingler said. Klingler said. Wait, so the deputies, the attorney for the deputies, said that the threats were not even coming from Adams County, but from the West Coast. Gosney, if you're still there, correct me if I'm wrong, but wouldn't irreparable injuries to the reputation have to be reputation from within the county itself? Isn't that where the reputation would matter most? The deputies say Afroman's social media posts and use of their images to sell songs and merchandise are not only damaging to their reputation and careers, but also putting their lives in danger. Their spouses were being harassed, and they were looking for any way possible to try to protect their families and try to get Mr. Foreman to stop spreading those malicious lies, Klingler said. It's not a lie that the sheriff's county or the sheriff's office busted into his house, searched his shit. Like, all it was is just, breaking his gate, breaking his door, rummaging through his CDs. Like, everything that they claim as a lie is on video. It's caught on video. Are you going to believe what Klingler tells them? Are they going to believe what Klingler tells them? Or are they going to believe what they see? Klingler also added that his clients should not be in Afroman's crosshairs, because at the end of the day, his clients were simply doing their jobs. I mean, a cop can harass me while simply doing his job, but if I feel harassed, I'm still harassed. If a person swats me, if a person does the swatting, the blame should go to the sheriffs for simply abiding by a unfounded allegation from a guy who decided anonymity is what he wanted to use, or a guy or girl wanted to use to attack someone else. This kind of justification would also be applicable to the Volusia County Sheriff dude who decided to arrest a 4chan user states away for a threat. They simply executed the search warrant, which is their legal duty to do. They also just didn't have to. They're not obliged to execute a search warrant. Castle Rock v. Gonzalez, they could have just not. The deputy's lawsuit is asking that they be compensated for any money generated through the merchandise and songs that use their names or images. Don't be public figures if you don't want to have your face or name used. Affroman says he intends to bring his own lawsuit against the sheriff's office, and hopefully he does and he wins. Oh, that's all to the story. Well, shit. I feel for Affroman. This fucking sucks. Imagine you're just a guy doing your own thing, having fun, and the fucking sheriff's county, or the deputy sheriffs of Adams County decides they want to fuck your day up. I'm starting to think back to your book, Gosney, about the infringements around the overlapping circles and circles of enumerated rights and unenumerated rights. It brings that to mind significantly. So I was going to go back over the Texas Senate Bill 8. Try to wrap it up, this 53-page document. But I think I have found a reason to not have to do that. Texas Scorecard, buse.com state. And this might be a way to wrap the show pretty early, because I don't really have much else to say. School choice rejected by Texas House. The budget amendment preventing state funds from being used on school choice programs. School choice advocates were dealt a major blow during the Texas House debate on the biennial budget on Thursday. A legislative priority of the Republican Party of Texas, school choice would allow parents to move their children out of public schools with the help of scholarships or tax credits. Democrat State Representative Abel Herrero Robstown offered an amendment that would stipulate that the money appropriated in the budget may not be used to pay for or support a school voucher, education savings account, or tax credit scholarship program, or a similar program through which a child may use state money or for non-public primary or secondary education. Members of the House approved the amendment. Fuck! I really wanted this to go through. I really, really did. God, why does everybody want... After House vote signaling opposition to school choice, Governor Abbott says the fight isn't over. The House this is like within the hour, basically. Governor Abbott said Friday he was not discouraged after the Texas House took a key vote to rejecting the highest priority on his legislative session. The House voted 86 to 51 on Thursday to amend the budget to ban the state funding for school vouchers or similar programs. Abbott has spent the past 2 months touring the state to build support for the proposal, spending tremendous political capital on trying to break through the rural republic opposition to it. The amendment came at a crucial time. The same day the Senate passed legislation to create voucher-like program, and 5 days before the House committee considered proposal on the subject. Governor Abbott made education freedom an emergency item this legislative session because no one knows the needs of their child better than a parent, Abbott spokesperson Renee Ease said in a statement. The amendment received the least support ever. This vote shows the legislature remains open to school choice. This vote shows the legislature remains open to school choice, supporting the majority of Texans who want to expand school choice. The 86 votes that the amendment received were less than the 115 votes a similar amendment to the House budget got during the latest legislative session. Other prior amendments on the issue have also garnered over 100 votes. The vote itself is essentially symbolic, as the amendment is expected to be stripped by the Senate before the final budget is passed. As the amendment is expected to be stripped by the Senate. Wait, so the House adds the amendment, and the Senate can take away the amendment. But it illustrates how the House may vote on the issue when a similar legislation comes to their chamber. Still, only 52 members voted in favor of school choice, far short of the 76-member majority needed to approve of such legislation in the House. 11 members stayed neutral by registering as present, not voting, signaling potential openness to the proposal, but still not enough to generate majority support, even if they all sided with Abbott. The House approved the amendment Friday after the Public Education Committee Chair, Representative Brad Buckley, Representative Colleen, asked members to table it given that his panel is set to hear legislation on topic Tuesday, but his motion to table failed 64 to 71, paving the way for an up or down vote. Since late January, Abbott has spoken at a dozen parent empowerment events, where he has pitched education savings account which would allow parents to use state funds to send their kids to non-public schools. Another sign Abbott is not giving up the issue. He is scheduled to hold his 13th parent empowerment event Thursday in San Antonio. That was yesterday. Or is that next Thursday? On the same day the House passed an anti-voucher budget amendment, the Senate approved legislation that would establish an education savings account program that would give parents up to $8,000 per student each year. Senators sought to appeal to rural Republicans by including a provision for districts with fewer than 20,000 students to receive $10,000 for every child who enrolls in the program and leaves their district. Oh, okay. So districts with fewer than 20,000 students to receive $10,000 for every child who enrolls in the program and leaves their district. So if you have less than 2,000 students, you would get $10,000 for every one of the 2,000 or 20,000 that leaves. So that would give a rural district school $200,000 back if all 20,000 students leave. Which is a lot of money, which they could put into being competitive again to get their students back. The Senate has already passed school choice legislation to the House, and the House committee will be taking up similar bills this coming week, he said. In the statement, Governor Abbott looks forward to the legislature passing school choice legislation this year, and signaling it into law and signing it into law to ensure all Texas students have access to the best education opportunities. So Senate Bill 8 might not be off my streams. I thought they were done because of the House Bill amendment. But it seems like there is a way to come back from this. This is not completely done. All right. Sounds great. No, that's New York State. I think I might just consolidate all the added materials from this document. And all the stuff that's been taken away. Though looking through it, it seems like there's there's a lot added. It would be nice. I actually am in strong favor of it. But of course, I'm not a parent, so I wouldn't know what a parent thinks about when it comes to these things. I can say the silver lining, though, with the denial of this bill, or the amendment to take out the subsidized private school tuition. They also, that's all that they decided they wanted to take out of it. So Senate Bill 8 has that portion of it out. That wouldn't take away from the rest of the bill. So the infringement on parent rights, the ability to understand what is happening to your students or to your child in the school system. It wouldn't take away this portion, and it wouldn't take away any of these rights to request instructional material review. It would just take away the whole use the state money to go to school. The right to information concerning students, except as provided by 3804. My bad. 3804. A parent is entitled to full information regarding school's activities. Okay. An attempt to withhold by any school district employee to encourage or coerce a student to withhold information from child to parent is grounds for discipline under sections 21-104, 21-156, 21-211. As applicable, or by the State Board for Educator Certification, if applicable, Section 110, Sections 2609 Education Code is amended by adding subsection A and adding subsection A1, A2, C, D, E, and reads as follows. A. An employee of a school district must obtain a written consent of a child's parents in the manner required by subsection A2 before the employee may conduct a psychological examination, test, or treatment unless the examination, test, or treatment is required under section 308, 3804, 3809. Child abuse, yep. unless under subsection 3804 or state or federal law regarding requirements for special education. 2. Subject to subsection B, make or authorize the making of a videotape of a child or record to or authorize the recording of a child's voice, unless authorized or by other law or collect, use, store, or discourse, disclose the child's private or identifying information. Unless authorized by other law, collect, use, state, store, or disclose, or a child's private or identifying information, including data, health and medical information, and biometric identifiers. Or 4. Provide health care services or medication or conduct a medical procedure. A1. For purposes of subsection A, biometric identifier means a blood sample, hair sample, skin sample, DNA sample, body scan, retina or iris scan, fingerprints, voice print, or record of hand or face geometry. A2. Written consent for a parent's child to participate in a district activity described by subsection A must be signed by the parent and returned to the district. A child may not participate in the activity unless the district receives the parent's signed written consent to the activity. C. Before the first instructional day of each school year, a school district shall provide to the parent of each student enrolled in the district written notice of any actions the district may take involving the authorized collection, use, or storage of information as described by A3. The notice must include a plain language explanation for the district's collection, use, or storage of the child's information, and the district's legal authority to engage in that collection, use, or storage, and 2. Be signed by the parent and returned to the district. D. A school district shall take disciplinary action against an employee responsible for allowing a child to participate in any activity described by subsection A4 if the district did not obtain the parent's consent for the child's participation in that activity. Ghazni, I want your opinion on something. If you're still there in the background. How do you feel about a school voucher system? Did you use public schooling? Or did you put your kid through private schooling, if that's not too personal? Section 111, Section 2611 Education Code is amended to read as follows. 2611 Local Grievance Procedure Complaints. So it strips complaints and local grievance procedures added, or a substitution. The Board of Trustees of each school district shall adopt a grievance procedure under which the board shall 1. Address the substitute complaint with grievance that the board receives concerning a violation of a right guaranteed by Section 109 or this chapter. A. The added text is A. If the grievance is filed before the later of I. the 90th day after the date of which the parent received notice of the incidents giving rise to the grievance, and II. the first day of the school year following the school year in which the incident giving rise to the grievance occurred, or B. regardless of whether the grievance was filed during the period described by paragraph A, if the grievance was informally brought to the attention of the school district personnel during the school year in which an incident giving rise to the grievance occurred, and 2. allow a parent at any time before a final decision by the board to amend the parent's grievance. So if the grievance is filed before the later of, if it's filed before the 90th day after the date of which the parents received notification. After the date on which the parent received the notice. So the time does not tick down when the grievance happens, but rather when the parent is notified. Interesting. The Board of Trustees of a school district is not required by subsection A or section 11-1511 B13 to address a grievance. In this document, I believe grievance now substitutes the word complaint to address a complaint. So now it's to address a grievance that the board receives concerning a student's participation in any extracurricular activity that does not involve a violation of a right guaranteed by this chapter. The subsection does not affect a claim brought by a parent under the Individuals with Disabilities Education Act or 20 U.S.C. section 1400 at section etc. at sequence or at section, or a successor federal statute addressing special education services for a child with disabilities. So this does not supersede federal law. The Board of Trustees of each school district shall ensure that each parent of a student enrolled in the district receives notice of the parent's rights under this title, that each parent of a student enrolled receives a notice of the parent's rights. The board grievance procedure under subsection A. The requirement to appeal to the commissioner in writing under section 757 if aggrieved by the school laws of this state or certain actions or decisions of any school district board of trustees. The requirement to appeal to the commissioner in writing under section 757. An appeal section, except as provided by. So the whole law here. Person is not required to appeal to the commissioner before pursuing a remedy under a law. Schools, alright. A person may appeal in writing to the commissioner if the person is aggrieved by the school laws or of the state or the actions or decisions of any school district board of trustees that violate the school laws of the state or provisions of written employment contracts between the school district and the school district employee. Alright. Alright, so now any district board of trustees. The board of trustees of a school district shall ensure a grievance procedure adopted under subsection A. 1. Authorize a parent to notify the principal or the parent's designee of the district campus. The parent's child attends regarding concerns related to rights guaranteed under section 109 or this chapter. A violation of section 2822, 2804, 2843, or 3323, or chapter 38, or the implementation of those provisions by the district, or C. Violation of chapters 551 Government Code requires that a principal or the principal's designee acknowledge receipt of a grievance under subdivision 1 not later than 2 school days after the receipt of the grievance. not later than the 14th day after the receipt of the grievance described by subsection 4. Acknowledge the receipt under subdivision 1 not later than 2 school days after the receipt of the grievance, and not later than the 14th day after the receipt of the grievance described by subdivision 1. I resolve the issue that gave rise to the grievance to the satisfaction of the parent who submitted the grievance. Provide to the parent who submitted the grievance a written explanation of the principal's reason for not resolving the issue to the parent's satisfaction. 3. Requires that not later than the 30th day after the receipt of the grievance described by subdivision 1, if the principal fails to resolve the issue to the parent's satisfaction, the superintendent or the superintendent's designee, A. Resolve the issue that gave rise to the grievance to the satisfaction of the parent who submitted the grievance, or B. Provide to the parent who submitted the grievance a written explanation of the district reason for not resolving the issue to the parent's satisfaction. And 4. Requires that not later than the earlier of the 30th day of the receipt of the grievance described by subdivision 1, or the next meeting of the board, if the superintendent fails to resolve the issue to the parent's satisfaction, the board in closed session resolves the issue that gives rise to the grievance, or has a written explanation as to why they did not resolve the issue to the parent's satisfaction. The parties may mutually agree to adjust the timeline for the procedure under this section. Grievance hearing before hearing examiner. This is section 112, chapter 26. Oh boy. 111 grievance hearing before A. If a grievance filed with the Board of Trustees or of a school district under Section 2611 is not resolved to a parent's satisfaction, the parent may request that the commissioner appoint a hearing examiner with the same powers and qualifications of a hearing examiner under subchapter F, chapter 21, to review the grievance and make recommendations to the State Board of Education regarding its resolution. I just made a realization that I've been reading this whole thing, but this is mostly just damn it. I started reading this with the intention of getting to the point of the school voucher system, and I've been reading about disciplinary means, how it was going to give parents rights. What is this bill called again? Bill to be entitled Enact. It's basically, what is it being classified under the news? Senate Bill 8, Texas. '88R. 88th Legislature. Is it being called school vouchers? Because I'm starting to realize that this bill does a lot more than school vouchers, but it wants to add school vouchers. The parent must file a written request for hearing. I'm guessing if there's not a good enough measure investigation by Attorney General, the Attorney General may receive an investigation of parents' complaints related to an immediate threat to the mental, emotional, and physical bodily integrity, safety, or individual liberty of a parent's child at the school district, including complaints regarding district's failure to notify the parents. So basically, if they don't comply with any of the stuff that it says, basically the Attorney General's made to know it. Sexual orientation. Restrictions regarding sexual orientation and gender identity. Instructional materials parent portal. Man, if you've got a tech-savvy parent and they're basically nose deep in your education programs, they'll probably figure out what you're... and they want to know where you're at in your school education. They could figure out what kind of homework you got to do that night, and then they could whoop your ass if they find out you're not doing your homework. So I realized I got off into the weeds of this bill to read through it when my main goal was the school voucher system. So let's read the education savings account program that was defined in this bill to save on time and frustration and my throat. Because goddamn, this is what I was here for. Article 2, Education Savings Account Program. Section 201. Article 1, Parental Rights, School Library. Why didn't I give it a cursory look? To anyone watching, I had spent the last couple days reading through this document to try to figure out what the school voucher system said to understand it better. I was reading Article 1 of this straight through when Article 1 was Parental Rights, School Libraries, and Curriculum. There are three articles in this whole document. And one of the articles had exactly what I was looking for. I am a fool. The purpose of this article is to provide additional education options to assist families in the state in exercising the right to direct the educational needs of their children and achieve a general diffusion of knowledge. Section 2.2, Chapter 29, Education Code is amended by adding subchapter J to read as follows. Education Savings Account Program. 351 definition in this chapter, account means the education savings program established under the program. Certified Educational Assistance Organization means an organization certified under Section 29.354 to support the administration of the program. Child with disability means a child who is eligible to participate in the school district special education program under Section 2903. Higher education provider means an institution of higher education or private or independent institution of higher education, as those terms are as defined by Section 6103. Parents means a resident of a state who is a natural or adoptive parent managing or possessory conservator, legal guardian, custodian, or other person with legal authority to act on behalf of a child. Program means the program established under the subchapter. Program participant means a child and a parent of a child enrolled in the program. 2935-2 establishment of program. The comptroller shall establish a program to provide funding for approved education-related expenses of children participating in the program. I want to take a moment to tell people that I've been fucking stupid. The program fund, or 29,353, program fund A. The program fund is an account in the General Revenue Fund to be administered by the Comptroller. The fund is composed of general revenue transferred to the fund, money appropriated to the fund, gifts, grants, and donations received under Section 23,370, and 4. Any other money available for purposes of the program. C. Money in the fund may be appropriated only for the uses specified by the subchapter. 29,354, selection of certified education assistance organizations. A. An organization may apply to the Comptroller for certification as a certified education assistance organization during an application period established by the Comptroller. To be eligible for certification, an organization must have the ability to perform the duties and functions required of a certified educational assistance organization under the subchapter. Be in good standing with the state, and 3, be able to assist the Comptroller in administering the program, including the ability to A. Accept, process, and track applications for the program. B. Assist prospective applicants and the program participants with finding pre-approved education services providers and vendors of educational products, and C. Verify the program funding is used only for approved education-related expenses. C. The Comptroller may certify one or more educational assistance organizations to support the administration of the program by 1. Administering A. The application process under Selection 29,356. B. The program expenditures process under Sections 29,360. And 2. Assisting prospective applicants, and program participants with understanding approved education-related expenses and finding pre-approved education service providers and vendors of educational products. All that goes to say, basically, it's someone's job to help people find which one of these, education assistant organizations become certified, and help parents and students find properly certified individuals. Should test that out. $29,355. Eligible child. A child is eligible to participate in the program if the child is eligible to the child 1 is eligible to A. Attend a public school under Section 2501. B. Enroll in public schools pre-kindergarten program under Sections 29,153, and 2. Either A. is enrolled in for the current school year or in a public school. B. Attend a public school for at least 90% of the preceding school year, or C. is enrolling in pre-kindergarten or kindergarten for the first time. A child who establishes eligibility under this section may participate in the program until the earliest of the following dates: the date on which the child graduates from high school, A child the child graduates from high school. Wait. The date on which the child is no longer eligible to attend a public school under Section 2501. Probably some sort of disciplinary removal, something like that. Maybe, I don't know. The date on which the child is no longer the date on which the child enrolls in a public school, including an open enrollment charter school, in a manner in which the child will be counted towards the school's average daily attendance for purposes of allocation of funding under the foundation school programs, or the date on which the child is declared ineligible for the program by the comptroller under the subchapter. Application to the program. A. The parent of an eligible child may apply to the Certified Education Assistance Organization to enroll the child in the program for the following school year. The comptroller shall establish monthly deadlines by which the application must be completed and submit an application form to participate in the program. B. On receipt of more acceptable applications for admission under the section than available positions in the program due to insufficient funding, a certified educational assistance organization shall, for 2/3 of the available positions, prioritize applications who would otherwise attend a campus with an overall performance rating under sections 3954 of C, D, or F. Fill the remaining 1/3 of available positions with applicants who would otherwise attend a campus with an overall performance rating of section 39054 or 3954 of A or B. Fill 2/3. Alright, so of insufficient funding, a certified educational assistance organization shall, for 2/3 of the available position, prioritize applicants who would otherwise attend a campus with an overall. So if they get a C, D, or an F, they will be here. And fill the remaining 1/3 of available positions of applicants who would otherwise attend the campus with an overall performance of an A or B. Subject to subdivision 1 and 2, consider applicants in the order received. A certified educational assistance organization shall create an application form for the program and make the application form readily available through various sources, including the organization's internet website. The application form must state the monthly application deadlines established by the comptroller. Under A, each organization shall ensure that the application form, including any required supporting document, is capable of being submitted to the organization electronically. A certified educational assistance organization shall post on the organization's internet website an application or an applicant and participant handbook with a description of the program, including 1. Expenses allowed under the program under section 295359, a list of pre-approved education service providers and vendors of educational products under section 29358. A description of the application process under the section and the program expenditures process under section 29.360. And 4. Describe a description of the responsibilities of program participants. A certified educational assistance organization shall annually provide to each program participant the information described by subsection D. The organization may provide the information electronically. F. A certified education assistance organization 1. may require a program participant to submit annual notice regarding the participant's intent to continue participating in the program for the next school year, and 2. may not require a program participant in good standing to annually resubmit an application for continued participation in the program. So if you go through the program, you're not required to resubmit into the program if you're within good standing. I guess this is to help reduce the bloat. Section 29.357, participation in program. To receive funding under the program, a parent of an eligible child must agree to spend money received through the program only for expenses allowed under Section 29.359. 2. Share or authorize the administration of an assessment instrument to share with the program participants, certified education assistance organization, the results of any assessment instrument required to be administered to the child under sections 29.35, B1B, or other law. Subsection B, Chapter 1, Section B. I'll need to figure out how to read that. 3. Refrain from selling an item purchased with program money in accordance with Section 29.359, subsection A, Chapter 2. Yeah, I definitely need to understand how to read that. Until the end of the 12th month after the date the item is purchased, and 4. Notify the program participants, certified education assistance program, not later than 30 days after the date on which the child A. enrolls in a public school, including an open enrollment charter, and B. graduates from high school, or C. is no longer eligible to either enroll in a public school under Section 25.01 or II, enroll in a public school's pre-kindergarten program under Section 29.153. Section 29.358, pre-approved providers, the comptroller shall by rule establish a process for the pre-approval of education service providers and vendors of an educational program products service. Establish a process for the pre-approval of educational services or education service providers and vendors of educational products for participation in the program. Comptrollers shall allow for the submission of applications on a rolling basis. The comptroller shall approve an educational service provider or vendor of educational products for participation in the program if the provider or vendor for a private school demonstrates a accreditation by the organization recognized by the Texas Private School Accreditation Commission or the agency and annual administration of a nationally norm-referenced assessment instrument or the appropriate assessment instrument required under subchapter B, Chapter 3.9. For a public school demonstrates accreditation by the agency, and B, the ability to provide services or products to program participants in a manner in which the participants are not counted towards the school's average daily attendance. 3. For a private tutor, therapist, or teaching service, A, demonstrates that the tutor, therapist, or each employee of the teaching service who intends to provide educational services to a program participant, I, is an educator employed by or retired educator formerly employed by a school accredited by the agency, an organization recognized by the agency, or an organization recognized by the Texas Private School Accreditation Commission. Just going to do this 1, 2, 3. 2, holds a relevant license or accreditation issued by the state, regional, or national certification or accreditation organization. Or 3, is employed in or retired from a teaching or tutoring capacity at a higher education provider. B, the tutor or therapist or each employee of the teaching service who intends to provide educational services to a program participant either completes a national criminal history record information review, or 2, provides to the comptroller documentation including that the tutor, therapist, or employee as applicable has completed a national criminal history record information review within a period established by comptroller rule, and the tutor or therapist or each employee of the teaching service who intends to provide education service to a program participant is not included in the registry under section 29 or 2292. Holy shit. For higher education provider, demonstrates nationally recognized post-secondary accreditation, or 5, for any provider or vendor not described by subdivision 1, 2, 3, or 4, presents any necessary supporting documents concerning the provider's or vendor's qualification to serve program participants. So these were subsections 1, 2, 3, 4, subsection 4. C, the comptroller shall review the national criminal history record information or documentation for each private tutor, therapist, or teaching service employee who submits information for documentation under this section, and verify that the individual is not included in the registry under 2292. Oh, people are not. Okay. Person is not eligible. That the individual is not included in the registry under section 2292. The tutor, therapist, or service must provide comptroller with any information requested by the comptroller to enable the comptroller to complete the review. An education service provider or vendor of an educational products shall provide information requested by the comptroller to verify the provider's or vendor's eligibility for pre-approval under subsection B. The comptroller may not approve a provider or vendor if the comptroller cannot verify the provider's or vendor's eligibility for pre-approval. An education service provider or vendor of educational products that no longer satisfy the requirements of this section must notify the comptroller no later than the 30th day after the date that the provider or vendor no longer meets the requirements. This section may not be construed to allow a learning pod as defined by 2701, or homeschool to qualify as a approved education service provider or vendor of education products. Huh. Learning pod means a group of children who, based on voluntary association of a children's parent, meet together at various times to participate in or enhance the child's primary or secondary academic studies. So, learning pod or homeschooling is not abided by, or not acceptable, or not to be considered for this. I realize that there is added text basically under every section of this because it's basically brand new law. Approved education related expenses. Just making sure I didn't lose. Okay. Subject to subsection B, money received under the program may not be used only for the following educational related expenses incurred by a child participating in the program at a pre-approved. Money received under the program may be used only for the following education. Okay. May be used only for the following education related expenses incurred by a child participating in the program at a pre-approved education service provider or a vendor of an education product. Of educational products. 1. Tuition and fees for a private school as defined by section 111.01 Education Code. The purchase of textbooks or other instructional materials or uniforms required by a school, higher education provider, or course in which the child is enrolled. Costs related to academic assessments. Fees for service provided by private tutor or teaching services. 5. Fees for transportation provided by a fee-for-service transportation provider for the child to travel to and from a pre-approved education service provider or vendor of education services or education products. And 6. Fees for educational therapies or services provided by practitioners or providers only for fees that are not covered by any federal, state, or local government benefits such as Medicaid or Child's Health Insurance Program, CHIP, or by any private insurance that the child is enrolled in at the time of receiving the therapies or services. B. Money received under the program may not be used to pay any person who is related to the program participant within the third degree by consanguinity or affinity as determined under Chapter 573 Government Code. What? Oh, nepotism prohibition. Okay. A finding that a program participant used money distributed under the program to pay for an expense not allowed under section or subsection A does not affect the validity of any payment made by the participant for an approval education expense. Finding that a program participant used money for an expense not allowed does not affect the validity of any payment made by the participant for an approved education-related expense that is allowed under section. Okay. So if you spend like 90% of your money wisely and then 10% of it unwisely, the 90% is not suddenly invalid. Program expenditures. The comptroller shall disperse from the program fund to each certified education assistant organization the amount specified under section 2936(1)(a) for each program participant for whom the organization administers an account. B. To initiate payment to an education service provider or vendor of educational products for an expense provided or an expense approved under section 293359. The program participant must submit a request to the participant's certified educational assistance organization. C. Subject to subsection D in sections 29362Q and 29364. On receiving a request under subsection B, a certified education assistance organization shall verify that the request is for an expense approved under section 29359 and not later than the 15th business day after the date the organization verifies the request. Send payment to the education service provider or vendor of educational programs. I need to reread all of this. Disbursement under this section may not exceed the program's participant's account balance. A certified educational assistance organization shall provide participants with electronic access to the program's participants' current account balance, the payment into initiation process under subsection B, and 3. Shit, hold on. Sorry. That was my waking up alarm. Which means I would have crossed the 3-hour mark if I didn't start 15 minutes late. A disbursement under this section may not exceed, account balance, the payment initiation process under subsection B, and 3. A summary of the program's participants' past activities, including expenditures in selected educational service providers or vendors of educational products. Amount of payment financing 29361. Amount of payment financing. Regardless of the monthly deadline by which the parent applies for enrollment in the program under section 29356A, the parent of an eligible child shall receive each year that the child participates in the program an annual payment from the state from funds available under subsections 29353, the child's account in the amount of $8,000. This subsection applies only to a school district with a the subsection applies only to school districts with students enrollment of less than 20,000 for the first 2 school years during the child residing in the district participates in the program. The school district to which this subsection applies is entitled to receive $10,000. Any money remaining in the child's account at the end of the fiscal year is carried forward to the next fiscal year unless another provision of the subchapter mandates the closure of the account. So if you spend $7,000 in 1 year, you get $1,000 added on to your next year, so you have $9,000 to work with the next year. any rollovers after that. The parent of a child participating in the program may make payments for the expenses of education program services and products not covered by money in the child's account. In the program may make money for the expense of education program services and products not covered by money. A payment under subsection A may not be financed using federal money or money from the available school fund or instructional materials fund. Payments received under this subchapter do not constitute taxable income to the eligible child's parents unless otherwise provided by federal law. Not later than May 1st of each year, the agency shall submit to the comptroller the data necessary to calculate the amount specified under subsection A. Administration of accounts. The account comptroller shall make quarterly payments to each program participant's account in equal amounts on or before the first day of July, October, January, and April. The comptroller may deduct an amount from each quarterly payment to a program participant's account to cover the comptroller's costs of administering the program. The comptroller may deduct an amount from each quarterly payment to a program participant's account to cover the comptroller's costs of administering the program. The amount deducted may not exceed 3% of the payment. So 1 or 2%. 1 to 2 to 3%. For each quarter, the comptroller shall disburse to each certified education assistance organization an amount from the total amount of the money appropriated for purposes of this subchapter to cover the organization's cost of administering the program. The total amount disbursed to a certified education assistance organization under the subsection for a fiscal year may not exceed 5% of the amount appropriated for the purposes of the subchapter for that fiscal year. The comptroller shall calculate each certified educational assistant organization disbursement under subsection C by multiplying the total amount to be disbursed by the average percentage of the program participants served by the organization during the preceding 3 months. On or before the first day of September and March, a certified educational assistance organization shall verify with the agency that each child participating in the program is not enrolled in a public school, including an open enrollment charter school, in a manner in which the child is counted towards the school's average daily attendance. For purposes of the allocation of state funding under the Foundation School Program, and to notify the comptroller if the organization determines that a child participating in the program is enrolled in a public school, including open enrollment charter school, in a manner in which the child is counted towards daily attendance for purposes of allocating state funding under the school. Yeah. God damn. The comptroller, by rules, shall establish a process by which a program participant may authorize the comptroller to make a payment directly from the participant's account to a pre-approved education service provider or vendor of educational products for an expense allowed under Section 29359. On the date on which the child who is participating on the program is no longer eligible to participate in the program under Section 29355, and payments for any expenses allowed under Section 29359 from the child's account have been completed, the child's account is closed, and any remaining money is returned to the state for deposit in the program fund. So when your child is done using the money is not yours. the money goes back to the state. By any so random auditing, suspension of account, the controller shall suspend the account of a program participant who fails to remain in good standing by complying with applicable law or requirement of programs. Tuition fees and refund prohibited. An education service provider or vendor of educational service or educational products may not charge a child participating in the program an amount greater than the standard amount charged for the service product by the provider or vendor. An education provider or an education service provider or vendor of educational products receiving money distributed under the program may not in any manner rebate, refund, or credit to or share with a program participant or any person on behalf of the participant any program money paid or owed by the participant to the provider or vendor. Referral to district attorney. If the comptroller or certified education assistance organization obtains evidence of fraudulent use of an account, the comptroller or organization shall notify the appropriate local county or district attorney with jurisdiction over the residents. Special education notice. A certified education assistance organization shall post on the organization's internet website and provide to each parent who submits an application for the program notice that the state states that a private school is not subject to federal and state laws regarding the provision of education services to a child with disability in the same manner as a public school. Two, provides information regarding the rights to which a child with disability is entitled under federal and state law. If the child attends a public school, including rights provided under the Individuals with Disabilities Education Act, and B, rights provided under subchapter A private school in which a child with disability who is a program participant enrolls shall provide to the child's parent a copy of notice subchapter required under subsection A. So program participant, providers, and vendor autonomy. Education service provider or vendor or educational products that receives money distributed under the program is not a recipient of federal financial assistance on the basis of receiving that money. A rule adopted or action taken related to the program by an individual, government entity, court of law, and or program administrator may not consider the actions of an education service provider, vendor, education products, or program participant to be the actions of an agent of state government to limit an education service provider ability to determine the methods to use to educate the provider's students or to exercise the provider's religious or institutional values, or provide a program participant's ability to determine the participant's education content or to exercise the participant's religious values. 3. Obligate the education service provider or program participant to act contrary to the provider or participant's religious or institutional values as applicable. 4. Impose any regulation on an education service provider, vendor of educational products, or program participants beyond those regulations necessary to enforce the requirements of the program. Or 5. Require the condition of receiving the money distributed under the program. An education service provider to modify the provider's creed, practices, admissions, policies, curriculum, performance standards, employment policies or assessments, or B, a program participant to modify the participant's creed, participation practices, curriculum performance standards, and assessments. In a proceeding challenging a rule adopted by a state agency or officer, under the subchapter, the agency or officer has the burden of proof to establish clear and convincing evidence that the rule is necessary to implement or enforce the program as provided by the subchapter, does not violate this section, does not impose an undue burden on a program participant or an education service provider or vendor of educational products, the participant that participates or applies to participate in the program, and the least restrictive means of accomplishing the purpose of program while recognizing the independence of an education service provider to meet the education needs of the students in accordance with the provider's religious or institutional values. Student records and information. Whew. Rules and procedures. Appeal judicial review. Program participant to let the controller administrate decisions. Right to intervene in civil actions. Ooh, this is interesting. A program participant, education service provider, or vendor of educational products may intervene in any civil action challenging the constitutionality of the program. A court in which civil action described by subsection A is filed may require that all program participants, education service providers, and vendors of educational products wishing to intervene in an action file a joint brief. A program participant, education service provider, or vendor education of educational products may not be required to join a brief filed on behalf of the state or a state agency. Oh. Comptroller is entitled to obtain criminal history records, information maintained by the department about a person who is a private tutor, therapist, or employee of a teaching service or school who intends to provide educational services to a child participating in the program. Nice. Everything else is not new text. No later than 15th of 2000 applies beginning with the 24 to 25 school year, no later than 2013. And Article 3 is simply just the effective date in which this applies, I think. Except as provided by subsection B of the section, this act takes effect immediately if it receives a vote of 2/3 of all the members elected to each house as provided by section 39, article 3, Texas Constitution. If this act does not receive the vote necessary for immediate effect, this act takes effect September 1st, 2023. Article 2 of this act takes effect September... Yeah, basically the same thing. And that is the school voucher program, Texas Senate Bill 8. I skipped over a large portion of that at the end because it related to something I didn't care about. It's just... What's it? gifts, grants, donations, annual reports, judicial review, and student records and information. Annual report's probably like a report card. Something to kind of state the record of the student's progress. So yeah, that's the state voucher program. That's what Brandon Creighton, a few others were looking at. The Texas House action seems to disagree with it. They made an amendment to try to scratch it out. There's possibility that the Senate will just make an amendment to re-add it back in if it gets approval, and that's about it. I hope this passes because I think it will actually be a benefit to the states, or to the Texas state education program. I know rural schools have a huge issue with it. That exception with the 20,000 students or less than. Hopefully will entice them enough to want to vote for it. But if not, it's fine. That's not my system, and hopefully I don't have to raise a kid through the current system. I think we should try it out, even if it has some shortcomings, because even public school has its own significant shortcomings. I'm hopefully done with this topic. I'll probably cover more when it updates. Oh boy. I filled out 3 fucking hours. Danielle Gosney, are you proud of me? I did it. 3 hours. I went through one whole document, a majority of another document. And Affroman is fighting back. God forbid the sheriff county in Ohio wins. I'm still mad about that Voucher County thing with the 4chan user. God, that's so annoying. But anyway, I am worn out from all the reading. My body is probably ready for manual labor, which I'll have to do in about an hour 30 minutes. And thank you to anybody who came to watch. Thank you to anybody who comes to watch later on the replay. Hopefully my reading skills have improved. I gotten a little bit better at reading these documents. I seem to have been able to keep up with it a lot longer. So I'm actually pretty happy about that little bit of performance improvements. Hopefully it'll get better and better and better. But if not, I'm in a good spot. Hopefully I'll be able to do more. And with that, thank you for watching. Thank you for visiting. Hopefully you'll leave a like on the video. And if you liked anything that I did, please go check out my locals. Go support it, subscribe, check out my Twitter. I'll try to use that more often. Try to tweet out when I stream. Hopefully get Twitter blue. Check out the Dragon's Treasure because the Venus Magical Girl Venus was actually pretty good. It tasted citrusy, good orange. Very much liked it. So with that, thank you. I gotta get ready for my day job or my night job. Hopefully get enough energy in me to bust out 11 properties. And with that, thank you for coming.